My name is Michael Mills. I am a lawyer. I practiced for a bunch of years. I stopped practicing a bunch of years ago too, and have spent time in law and technology in a variety of different roles. My friends at Clio asked me to come and talk a bit about a view of the way in which law can be practiced that comes out of not only the experience I've had in working in law firms, but also the experience I've had in working in a little software company that some friends and I started a few years ago. When I came into the room a few minutes before you did, there was the results of a poll on screen from the last session. And apparently the audience had been asked, do you still have a fax machine in your office? And I was pleased to see that we're down from 100% to 35% still have fax machines. That's, by the pace of technology, I think for the legal profession, pretty rapid. It's only taken 30 years to get from the advent of email down to only 35% of us use fax machines. What I'd like to do today is talk a little bit abstractly about some general ideas about what the practice of law is or isn't. And then I'd like to show you some examples of things that people have done that pursue a somewhat different vision of what law practice can be. Now, as it happens, the things that I'm going to show you were built with my company's software, but this is not about my company's software. The things that I will show you can all be built with many different kinds of software. There are some terrific software companies here. They've all got really smart programmers, and you can go find your own really smart programmers and do anything here. So this is not about my particular company's technology. We have been practicing with this, so next. There we go. Apparently if I speak at it, it's like Siri, you just have to talk to it. What you see on screen is something that a law firm developed because their client said, you know, you give us a memo when we ask you a question, but a memo isn't an answer to my question. And I have, this is a very arcane topic having to do with what bankers can do when they're trying to sell things to clients who are not organized as United States corporations. The substance of the law doesn't matter, but the business problem that it solves does. The folks who need answers to these questions are busy and impatient and frugal, rather like most clients. And they said, I don't want to read a 5-page memo or even a 2-page memo. I just want to know the answer. Can I do it or not? So a law firm built this little application that runs on a phone or on a big computer as here that answers that question. And baked into that software is the law of a whole bunch of countries and about a whole bunch of products, so that those business folks can get a specific answer to their question and they can make a business decision and move forward. Is it as good an answer as they would get if they sat down for half an hour with a lawyer and had a conversation? No, but that isn't what they wanted. They wanted an answer to a practical question that would allow them to move forward and do what they wanted to do. So the law firm, which was accustomed, as all of us who practice law are, to thinking, well, there's a lot of nuance here. We really just have to chat and we have to go back and forth. We have to write a memo. It's got footnotes in it and it's got citations in it. The client said, no, I'm just trying to decide what to do. So they used software to build what in finance you'd call a model of the law in order to give those clients an answer on a phone instantaneously. So let me talk a little bit more generally now with that example in mind. If you look back 25 years or so when lawyers were relatively cheaper in the marketplace, people brought a large set of problems to law firms. And this is true in corporate law practice for the AmLaw 100, and it's true at every level of practice. People would walk in your door with a range of problems, but over the time, as the perception and the reality of the expensiveness of lawyers set in, people stopped bringing as many general questions to lawyers, and over time, the pool of problems that lawyers were asked to solve shrank. It became more the stuff at the top end of the bell curve, the more critical problems for which lawyers are really essential. And the old days of the more general, informal, chatty advisory relationship have disappeared. So one of the things that as a business model you might want to think about is how do you get back some of that work, and how can you do it cost effectively in a way that serves your clients, builds relationships with clients, serves a broad spectrum of their needs, and allows them also to bring you, of course, the high value work at the top. Now, some of you know there's a well-known futurist in the law named Richard Susskind who's written a bunch of books, and he has a diagram that looks like this. On the left-hand end, over my left shoulder on that side and right shoulder on this side, is the fancy work that is the traditional stuff of lawyering. It requires empathy, it requires judgment, it requires personal interviews, the human touch. And on the far right-hand end is LegalZoom, or the early version of LegalZoom, before they had lawyers involved, and there were just machines involved. In the middle of that, between those two poles, the most traditional legal work by people in wigs and long black robes, and on the right-hand end, LegalZoom, is a very large spectrum of legal questions and legal issues that people have problems about and want answers to. So Susskind proposes this spectrum from the bespoke. He's an Englishman or a Scotsman, so he uses that word rather than just custom, the way we would here. And first, the thing you do is standardize. You try to build some forms in your practice, and you try to organize so that you have a checklist, and you do things in a systematic way. And then you may begin to wrap some of that in technology. You may use document assembly programs or others of the many interesting tools here that are integrated with the Clio platform. And in that green box of systematized and packaged is where I'm talking today. And the opportunities for innovation in law practice are, of course, at the left-hand end. That's where we as lawyers are the most creative, solving the newest and most interesting problem for our clients. But in that middle, where you can systematize and package what you know, you can take your expertise and wrap it in things that enable people to use it effectively. There is also tremendous opportunity for innovation, as some of the folks out there demonstrate. There's a guy named Jeff Carr who talks about what law practice is a good deal, and he puts law practice into 4 buckets: counseling, advocacy, process, and content. Counseling and advocacy are the traditional business of lawyers. It's the stuff we like to do, it's the stuff we went to law school to do, and it's the stuff only human beings can do. Process and content, however, the mechanics that underpin a lot of law, can be systematized and packaged in interesting ways. Now, there has been in the profession over the last, in some ways, 25 years, the ABA published a book on alternatives to the billable hour in 1989. But in fact, in the last 10 years, there has been much more attention in practice to ways of billing other than the hourly, the traditional hourly fee. There was in one of the panels this morning, Joshua Lennon from Clio asked the panel members on what basis do they bill. And Conduit Law, an interesting startup in Canada, 90% of their work is done on a basis other than the hourly bill. And you'll see that more and more in law firms. But the interesting thing about all of these on the screen in front of you, and these are different flavors of something other than hourly billing, is that they all, in the end, depend on a lawyer working an hour. Now, you can use practice technologies like document automation and Clio and automated billing and all kinds of tools to make your hour more efficient. You can produce more in that hour, and you can thereby drive down the cost of the service that you deliver, or improve the margin if you can keep the cost constant. But in the end, all of these are built on a model. It's the craftsman model. It's the one I grew up in as a young lawyer, and indeed carried on as a not so young lawyer, in the model in which I do work, I work for an hour, and something comes out of that. A brief, an argument, a transactional document, something comes out. So I studied economics for a while, and I thought, well, gee, that model really fits in with the traditional microeconomic analysis of marginal cost. And you've got across the top line, the green one, that's your revenue, and you get paid The x-axis, by the way, is quantity. The y-axis is money, expressed in dollars or US dollars, Canadian dollars, any kind of dollars you want. You get paid some amount of money for each unit of work that you deliver. It may be per outcome, it may be per hour, and your cost for that, if you apply smart practice technologies, you can push that red line down a bit, and you get a good profit margin in between those two. But notice that the lines are flat. And what that means in business terms and in personal terms for lawyers is that in order to earn another unit of revenue, I have to do another unit of work over and over and over again. That is the way shoes were made before the Industrial Revolution. Software companies and publishers and industrial companies, makers of cars and typewriters and telephones and all of those things, don't work on that basis. They look at ways in which they can drive the average cost of each unit of production down over time. And the result of that is that you get a curve for your cost line. As your quantity goes up, your cost goes down, and your profit margin improves. Bill Gates got rich for two reasons. One is that he outmaneuvered IBM in the early days of the DOS operating system. And the second is that he's in the software business, where the marginal cost of delivering the next unit of output is close to zero. It's not truly zero because you have to invest in R&D in order to make the next version of Windows and the next version of Office better, or at least more cluttered with features that you don't want to use. But the cost of delivering that to the next person, especially now that they've gotten rid of the boxes and the CDs, is pretty nearly zero. That's one of the reasons Microsoft has moved to a subscription basis and so on. But that fortune, Microsoft as a company and Oracle as a company, was built on the spreading gap between revenue and cost. And what I would suggest is this is the model, this is what the Industrial Revolution is about. You build machines to do work which drives down cost as quantity increases, which increases both output and revenue and profit. The legal profession has missed the Industrial Revolution. It's true that we have applied technology in our own slow-paced way, so that 35% of us still rely on a fax machine. But fundamentally, we have missed the Industrial Revolution because we are, by temperament and by organization, we are craftspeople. We build things one at a time. We build them a bit more efficiently than we used to, but we don't really build them on the industrial model. The great tools of the Industrial Revolution, the steam engine and so on, really don't have much applicability to law. We don't build big things. So the first rounds of the Industrial Revolution with steam and then electricity haven't helped us much. But computing power has. We are the ultimate computable profession. We deal in text, we deal in concepts, we deal in data. All of that is digitized these days from the beginning, but could have been digitized before. So the improvements in computing power matter more to us than they do to many professions and many occupations. This is there are lots of these charts showing the rise in computing power per dollar and so on, Moore's Law. I like this one because it's illustrated with brains along the right-hand side. It was done by Ray Kurzweil. And what he forecast, he did this about 4 years ago, he forecast that by 2020, computing power would be roughly equivalent to the mouse brain. Now that may not sound like a whole lot, but if you look at what lawyers do, it's actually more than adequate. So, with all of that computing power and with the cloud, because what the cloud does, as our friends at Clio know and have brought to you, is enable all of the benefit of that computing power increase to be scaled enormously. It's not just that the individual chip is better or that the individual server is better, it is that you can have 10,000 of them on 60 seconds notice at Amazon or Google if you need those servers in order to do something interesting. And the cloud has, the combination of the improvement in computing power per computer and the cloud have now put at your disposal and truly unimaginable degree of computing power. So what are you going to do with that? Well, one thing you're going to do with it is what Clio helps you do, which is to manage your practice, and what some of the document automation and other interesting vendors out there do. What I would suggest is that we can do more than that. And by using very, very smart algorithms, I'm not actually enough of a mathematician to have drawn this. I found this somewhere. But very, very smart mathematicians do a lot of thinking about algorithms that can be useful to you. The first in the legal profession was legal research. Behind Lexis, West, Fastcase, Lois Law, all of the legal research tools are very smart algorithms, which these days are called machine learning or artificial intelligence algorithms, which look at large piles of text and help you figure out which of those chunks of text are useful to you. And then they do nice visualizations and so on so that you can get right to the ones that are most relevant to you. The second wave of fancy algorithms in the legal profession and machine learning algorithms in the legal profession was in electronic discovery. The days in which I started in electronic discovery, we printed out the emails and then we read them. Well, you don't have to do that anymore. There's lots of really clever software that will dive into mail servers and do all kinds of very clever analysis to figure out which is the relevant email, which is responsive to a document request, and so on. The next wave is beginning to happen. You see it at the front edges of legal research in what Fastcase is doing and Ravel Law and folks like that. You see it in the front edge of what's being done in e-discovery. You see it in products like Lex Machina, which is a database with powerful algorithms behind it of intellectual property law. And what my friends and I in the industry are doing is trying to bring that computing power from the cloud with the very smart algorithms into a form that can be used to do things like answer that question that I showed on the first slide, to enable lawyers to build products that take their expertise and package it, systematize and package it, as Susskind suggests, and do that practically and efficiently. Think of Microsoft Excel. Before VisiCalc, which was the predecessor of Lotus 1-2-3, which was the predecessor of Excel, before VisiCalc, if you wanted to do complex financial calculations, you had to have a programmer, or you did it on a big green yellow sheet with a calculator. But if you wanted to do fancy stuff, you hired a programmer. What Dan Bricklin did in inventing VisiCalc and Mitch Kapor with Lotus and then Microsoft cloning all of that as they usually did and building a terrific product in Excel have done is to put immense computing power into your hands. You can get a copy of Excel these days for, I don't know, $9 a month under an Office 365 subscription. And you can build, if you're a finance person and know what you're doing, you can build extraordinary software with a tool that's at your desk and easy to use. Now, it's easy to use at the beginning. You need to read a book and maybe read 2 books in order to do the most powerful things with Excel. But you can do it. You do not need to go get somebody with a computer science degree to help you do financial modeling. In the profession, in the legal services space, some of the folks out there in my little company are trying to do that same thing to give you tools that you can use to build really powerful applications which serve your clients and answer questions. So we call these things expert systems. That's just a kind of a generic name. I like the more practical definition that expert systems are software that transforms what people know, what you in this room know, into practical answers in a form that other people can share. Again, think of what happens with Excel. You're a finance guy. You know everything there is to know about cash flow forecasting for Vancouver-based software companies that serve the legal services industry. And you build a model in Excel. You have taken a chunk of what you know, a combination of things that you read and expertise and judgment. You have baked it into the software. You have made it shareable. 1,000 people, 10,000 people can take that spreadsheet and use it to do cash flow forecasting for small software companies. The same thing is possible in law, and you see that in document automation, but in the example I showed in the first slide, you see it moving beyond document automation to actually giving legal advice. Expert systems are everywhere. Your doctor has in the pocket of her white lab coat a phone with at least one and probably several expert systems on that phone. This one you can buy, as you can see, for $159 a year at the App Store, and this is a diagnostic tool that doctors use all the time. It has built into it, just as the finance person did in Excel, it has built into it the expertise of the very best people, very good people, on a range of medical topics. It's particularly used for drug prescribing, drug interaction, diagnosis, and so on. TurboTax, how many of you use an online tax program to do your taxes? Lots, right? Well, TurboTax is a legal expert system. It has baked into it the knowledge of lawyers about 50 state tax laws, federal tax laws, and it does some quite remarkable things. It doesn't just fill out the squares or the rectangles on the IRS form. It advises you about how to minimize your taxes legally, tax reduction rather than tax avoidance. It advises you on deductions to take, contributions that you could have made, ways to structure what you do that find your way through in an optimal way through an incredibly complex, insanely complex, GDP-reducingly complex statute and set of regulations for 50 states and the federal government that gets changed every year. This is a giant expert system. But it's a legal expert system. So what does that mean a little more concretely? Well, on the left-hand side, you've got inputs of one kind or another. You've got data, which might come from Clio or any of the systems you see here, or you could ask somebody on a phone or an iPad. And in the middle is the magic box that does a bunch of analysis and reasoning and draws some conclusions. It may generate documents. It may write back into Clio or other databases. That's, in summary, an expert system. So with that, I want to jump quickly to some examples. What kinds of problems are expert systems good for? Well, as I said at the beginning, in thinking of Susskind's spectrum from custom to truly commoditized, and the trouble with commodities, by the way, is that there's no differentiation between suppliers. That's why in that diagram there was a red line before commoditized, because you don't want to be in the business of selling something that is truly undifferentiable from somebody else's. Expert systems are not about solving the problems that are most complex, most judgmental, most anxiety-ridden, most novel, law is changing, and so on. But lots of people and lots of businesses have lots of very routine questions. And this diagram was drawn for me by a guy who's a lawyer at a company. And he said, you know, when I think about what we do, I have a spectrum. I've got risk going vertically, higher it up, the bigger the risk. Could be dollars, could be reputational risk, whatever it is, family risk. And how frequently does the question come up as the bottom axis? And things that are really important, I pay a lot of attention to, and I go hire a lawyer and I'll go spend what I have to do to solve that problem. Life, either individual life or corporate life threatening activities and risks. But there's a lot of stuff that's very routine. And very often, it's not cost effective to bring a lawyer in to answer that. And that's true for us individually as persons. I don't call a lawyer when I need an answer to a question. I needed an answer the other day in a family matter to a question of how I could get a person in the state of New Mexico to write a document that would promise to pay me money, which I had loaned to that person. I'm not going to call a lawyer to do that. It wasn't that much money. But had I been able to get an answer online, ultimately I did get an answer, by the way, because I found an online form from somebody, a lawyer in that state, who somehow had decided to put on his website a form that allowed me to do it. And I did then consult that lawyer. So it's the frequent and routine, as with document automation, that is the proper domain of expert systems. So let me give you a few examples. I'm going to start with a couple of corporate examples and then move to some that are not. This particular practice, the Foreign Corrupt Practices Act practice, is really a big company problem for the most part, but the business analysis here is applicable to any practice. That nice man on the screen is named David Simon. He's a lawyer at that firm, Foley and Lardner. And he knows a lot about the Foreign Corrupt Practices Act, bribery and that sort of thing. And he spends his time doing traditional bespoke legal work in which he represents people who have gotten into bad trouble. Guys who give bags of cash to Chinese government officials when they shouldn't, and that sort of thing. And David said, you know, I enjoy doing that. I make a reasonable living doing it, but my firm has hundreds of company clients, and my firm doesn't have even many hundreds more of corporate clients who do business around the world, who are too small to have a compliance person on their own staff, an in-house lawyer, and yet they can get in trouble around the world by doing dumb things, having a salesman who does something wrong in Mexico, for example. So he said, let me think about how I can take my expertise and package it in a different way to serve a different market cost effectively. And he did that. He built a couple of interactive applications which are targeted not where he is currently doing his bespoke work, which he enjoys very much doing, but at a larger audience of companies, could be people, but it happens to be companies in this case, who have a similar set of problems about which he is expert, but which the traditional craftsman model of legal services cannot address. Think of an airplane. Airplanes take off. They're big, expensive. You buy them, you pay the mortgage on the airplane, and you buy the fuel. It launches up into the air and it flies across country. And its cost is constant, whether there's anybody on that plane or not. If it's Donald Trump by himself, it costs the same amount as if we were all traveling with him. And airlines figured out years ago that that's a real problem. So American Airlines famously developed very clever yield management software, which is now what drives us nuts when we try to buy plane tickets, because you can never figure out what the hell the ticket's actually going to cost. It'll cost something different if you call at 11 in the morning versus 2 in the afternoon, and if you agree to not fly on Thursday but come back on Sunday, all of that stuff. We are the victims of the yield management algorithms that the airlines now all use. And what are they trying to do? They are trying to fill that airplane to make sure that when it takes off with constant cost of aircraft and landing rights and crew and fuel, that it is full and that they are getting the maximum possible dollars, that they have jiggered the seating so that they can get as many first-class people as they can, and nonetheless, there will be not a single seat left on that airplane when it takes off. Lawyers don't do that. Lawyers have constant costs, ourselves, our law school debt, and our mortgages on our homes, and we have our office space and our associates, and all of those things are relatively constant costs. And we work hard, so 10 hours a day, 5.5 days a week, we work really hard. And yet, more than half of the working week, we're not earning anything. We're flying an empty airplane, because what you know about a subject matter, in fact, is good 24 hours a day, just as the airplane is useful when it's up in the air, but you're not selling the seats, so to speak. Systematizing, packaging, or productizing expertise is trying to apply the airline model, the airline yield management model, to professional services. And that's what David was doing. He said, I can only work so many hours a week, and I can only drive my associates to work so many hours a week. There are limits, you got to sleep and visit with your family and so on. But if I take some of what I know and build it into software, then particularly for a global practice, which is spread around the world and the clock, you can do interesting things to the bottom line. This one is done by a labor law firm. Labor law, as you might imagine, has got a lot of routine questions in it. Is this person an independent contractor or not? Do I have to pay overtime or not? And so on. So Littler, and we're involved in this one because this is a joint venture between my software company and Littler, produces a whole suite of applications, online interactive applications that allow people to answer labor law questions, get answers to labor law questions. There are all kinds of disclaimers and contractual terms to make sure that we're not violating the unauthorized practice of law questions. Please, if there's anybody here from a state bar association, let me assure you that we have ethics counsel and we have worked all that out. We are not in trouble. But let me show you now quickly a number of other examples. We have a program rather like the Clio Academic Access Program. I don't know whether you know about that, but it's a terrific thing Clio does, and they make their software available to law students for free. Rather the way Lexis and West did, one of the things it does as a marketing matter, of course, is connect law students to Clio. But it also teaches them good things about law practice and how law practices are managed and so on. And Clio also makes their software available to clinics in law schools, which is just terrific. Because think of that, they are law firms, they need management. We do something similar with a number of law schools. We make our software available to law schools. And these are from Georgetown Law School, where for the last 3.5 years, each semester, 32 students in a class called Technology, Innovation, and Law Practice get together. They spend the semester reading and studying and having visiting lecturers about the ways in which the practice of law is changing. And instead of writing a paper or creating a moot court brief, they use our software to build an application. And they're teamed up with a real client, with a not-for-profit organization or a government agency. And they're teams of 4 students who team up with a real client, and they build a real application which answers real questions. At the end of the semester, instead of moot court, they have a competition. They present the applications, and they win small prizes. This one was built by some Georgetown students. It is being used by a social services organization in New York called JASA, which serves the elderly in New York City. They provide social workers and nurses who go out and make home visits to people who have serious medical and other problems. And they came to the Georgetown students because they said, very often when our nurses are out, it turns out that the problem that the person has that they're worried about that day is not a medical problem. It is they might be evicted, or they have a debt problem. They have legal problems. So our nurses and social workers aren't equipped to deal with that. So this application runs on an iPad and is in the hands of those social service workers as they go around, and it was used 5,000 times this year to provide basic legal advice in the hands of these social service workers to elderly people who otherwise would have no way of getting legal advice about a problem. And now, we're very proud of the Georgetown students who built this, but it is an example of the way in which you can productize expertise and put it in the hands of people who need that information. This one happens to be not-for-profit, and these other Georgetown examples I'm going to show you are as well, but that's because it's a law school. There are other models in which this is not very much not-for-profit. Immigration, another area, very complex regulation. People want answers. DACA is called the Dreamers program, and it's a tricky set of rules. And if you're a kid who's a student somewhere, this application through the Immigration Advocates Network, gave them legal advice in a practical way. Richmond School of Law has built an application for veterans who have often, apart from the medical problems they have, which the VA may or may not choose to get around to treating, they often have regulatory and legal issues about their discharge. Does their discharge get in the way of getting medical benefits? Or are there other benefits that they might be entitled to? And there's no way that there's no number of lawyer hours that is going to answer those questions in the traditional one-on-one personal service model for the scores of thousands of veterans who have those questions. The only way those questions are going to get answered effectively is with technology, packaged and systematized in the Susskind term to give them answers. This is from Tennessee, another DACA application created by a group in Tennessee. Tennessee has a really good approach to the access to justice funding and management problem. Legal Aid Society of Tennessee, another one. Foreclosure assistance screening, again, for people, again, because these are law school projects, these are targeted at folks who truly can't afford legal advice at all. And Virginia Legal Aid Society, another application, this is used over and over again every day as an intake and screening tool to allow the legal aid lawyers to do the work that they actually can do, and to use this application to guide people who are not eligible for service, whom they don't want as a client or can't take as a client, to guide them to other forms of service, self-help in particular. Pennsylvania Health Law Project, another example. Medicaid appeals for people who have been denied Medicaid, particularly for children's issues. There are not enough lawyers to solve that problem. It is an area in which there are some people who are really experts. You build an application that allows people to act effectively for themselves. New York City earned sick time, new statute in New York, lots of people trying to figure out whether they're eligible for it. This application, again, walks them through. I'm not running live sessions of these. These are just the initial pages of these. Walks them through a series of questions. Think of it as a decision tree, although there's much fancier logic underneath it, and gives them an answer. And that's it. I'll take questions and we'll have a conversation. But as part of the formal presentation, I'm to tell you that there's a party tonight, and the buses leave at 6:30. Now, I can't use the standard late afternoon speakers line, I'm standing between you and the bar. I'm not. There's a bus between you and the bar, but they leave at 6:30 from the hotel. And the folks at CLIA would be delighted if you showed up and continued schmoozing. Now, I've been rattling on for a while with some kind of abstract notions about how you might think of your expertise as a way of filling an airplane more effectively, as a way of generating new forms of revenue, new forms of relationships with clients. And I've shown you a few examples of that, both in the commercial legal world and in the not-for-profit legal world. But now it's my turn to shut up and listen if you've got questions and comments.
Yeah, we've heard a lot about Watson, the IBM computer that went on Jeopardy.
Mm-hmm.
Do you have a particular take or where that specific project is?
Sure. IBM Watson, many of you may have seen when Ken Jennings, the world's most effective human player of Jeopardy, was beaten by software developed by IBM and a bunch of very powerful IBM computers. This was 4 years ago now. At the time, the set of computers that was playing Jeopardy would have filled about half of this room. It would now fill maybe the first 2 rows of seats. It has some really smart software, and it had a whole team of engineers who were training that software to win the Jeopardy game. IBM has taken that technology and turned it into a business unit called the Watson Business Unit. They're investing $1 billion in that business unit. And apart from running a lot of big ads, they're doing a lot of clever things to get folks to use that technology. One example outside of the legal field is at Memorial Sloan Kettering, the cancer hospital in New York. Watson has been digesting all of the medical literature, truly all of it. Everything that's in Medline, the National Library of Medicine, journals, test reports, patient reports, and so on. And a group of doctors at Sloan Kettering have tuned that, think of it as a really fancy search engine. They have tuned that search engine so that it can provide useful answers to questions that doctors ask about particular patients. An oncologist at Sloan Kettering, these guys actually do know what they're doing, will consult Watson, or the oncology version of Watson, for guidance, not dispositive controlling advice, but for guidance on treatment protocols that might be helpful. IBM is interested in the legal space. They are working with a small company started in Toronto called Ross, recently moved to Silicon Valley because that's where the excitement and funding is, they said. And they are building a bankruptcy advisor that operates in a similar way to the way Watson won Jeopardy. It is ingesting all kinds of bankruptcy literature, cases and regulations and whatnot, and will be able to provide answers to bankruptcy questions. My own view, you asked for my take on that, is that legal publishers will do very well with Watson. It's terrific technology. It's not the only game in town. My friends who are engineers at Google say, look, we've been doing that for the last 5 years. We just haven't given it a name and we don't sell it. We just use it to push ads. And there are a bunch of little companies around and big companies who do similar kinds of things. IBM has gotten a lot of attention for Watson. It's fantastic technology, but it requires oceans of text and raw material in order to produce good answers. Hence, I think the legal publishers will either license Watson, Thomson Reuters has just licensed Watson, not clearly for the legal division, or companies like Fastcase who have really smart engineers and access to the same algorithms that are behind Watson will just build their own. And that kind of technology as an answering tool to help lawyers find answers, very powerful. It's part of the artificial intelligence in the law movement, of which my little company is one small part. Question?
Michael, so if a solo or small firm wanted to build an expert system or get into this, where would they start? Where would they turn? How would they monetize it?
I would suggest that the place to start is actually not up here, but to start thinking about a piece of software that's familiar to everybody in this industry, document automation. That is, in fact, a form of expert system. The algorithms for decision making may not be as fancy, but you can do quite remarkable things with tools like HotDocs and some of the others. They're inexpensive, they're accessible, and the business thinking is the hardest part of it. The actual building of the technology is not that hard. When we work with law firms, for example, we tell them generally it's going to take us or your own staff 1/5 of the total project time. The 4/5 of the project time is the time of the lawyers thinking through what are they trying to do, what does their client want, doing the analysis that David Simon from Foley did in going to talk to his clients and to his prospective clients and figure out how could I create a different kind of service instead of, as lawyers tend to do, thinking what do I know and how do I present that to people, turning around and standing in the client's shoes and saying what problem does the client have and how does my expertise match that. So most of building expert systems or document automation systems is not really about technology. It is about thinking about a client's problem and business. So I think the way to start is to start with document automation because it's easy and accessible and you can do it now, and documents are one of the primary artifacts. Moving up the chain to building more complex systems, as I said, HotDocs, for example, has been used to build some quite remarkable things that look a lot like the applications you can build with our software. And if you're serious about it as a business matter and you've thought through what it is you're really trying to do, then I'm happy to talk to you. But our software is big and complicated, and it's easy to use, but underneath it's kind of complicated. So I wouldn't suggest starting there. Question? Yes, in the back. Yes, sorry.
Have any of these legal expert systems run up against difficulties ethically in terms of giving legal advice without representing someone?
No, because the folks who build them have been very careful. If you have to think through, and you have to do it state by state, what the rules are about creating an attorney-client relationship, what the rules are about unauthorized practice of law. This is where LegalZoom, as you know, in a bunch of states got into trouble, except in Texas where there's a statutory carve-out for document automation and software-delivered legal services. Texas is the only state in the country that has addressed this issue head-on and said, if it's software, it's not legal services. So you can build an expert system or a document automation tool in the state of Texas and be clear. In Missouri, where LegalZoom got sued first or second, not so clear. So the answer is you have to be careful. That's why we're one of the very few software companies that actually has ethics counsel. I guess Joshua serves as counsel for Clio in that respect. You're right. There was a question, yes, in the blue shirt.
You guys have talked a lot about document automation, and I think a little earlier you talked about how when you can get more effective at delivering documents, you can kind of lower your margin or lower your cost. And so I guess it's a little bit far from your point as far as software building, but then you kind of came back to it and were saying that document preparation is kind of the idea. And I think it was in the mid to late 2000s, you know, people like Stephanie Kimbrough, MC Talia, Forrest Most, and task representation. How do you see those types of models and service options that a lot of lawyers, like in California, I think Massachusetts has a limited scope representation assistance
Right.
training program plays into what you're describing as far as this adaptation of delivering documents in a more discrete manner?
Are you all familiar with the unbundled services or limited scope representation ideas? Will Hornsby from the ABA is here. He knows more about this than almost anybody. Technology does play a role in that, because if you're going to advise a person in part, you want to do that as efficiently as possible, and you want the piece that you're delivering in person on a traditional model to be surrounded by the best possible tools. So online intake forms, like what Intake 123 does, document tools, like a number of them that are out in the hall, or expert systems can be part of that. I think, in fact, to do unbundled services in the most responsible way, you really need to use technology, because you have, if you launch a practice on that basis, I think you have, if not a formal ethical, I think, actually most states you have a formal ethical obligation to advise your client about the limitations of that mode of representation. So you want to give them training wheels, or you give them additional forms of help by way of technology. So I think it's very important. Question there.
Michael, can you address the cost of such an endeavor to systematize some legal product?
Sure. And the answer is, it depends. If you want to build, we have a client who built an application that evaluates the bankruptcy risks in derivative transactions in 50 countries around the world. That cost a lot of money and took a lot of time. The little application that I showed you first, the sales restriction advisor, kind of medium-sized. The applications that I showed that the students have built generally represent about 20 hours of a lawyer thinking with them about what's required, what problem are we trying to solve, how do we solve it, what are the relevant rules and statutes and text, and about 40 to 50 hours of the students' time building, maybe 60 collectively among the team of 4, building those applications. And those are good examples because they're single issue focused. And remember that the students have got 10 weeks to do this whole thing. And they've got 3 other classes to go to. And they have to learn enough about the software, learn enough about the concept, and get the whole thing done in 10 weeks. That gives you some idea that it is a manageable problem. But I think the say 4-to-1 ratio or 3-to-1 ratio between lawyerly hours and more technology-related hours, and those can be lawyers. Indeed, the law students are lawyers, but it could also be a paralegal in your office who learns to use the software. Joshua, are we over time, or are we still counting down? Okay.
So Clio has very much wrestled with trying to figure out how to do document automation for every jurisdiction because of the different forms that are out there. So I think something that would be amazing to come out of this conference is for people in the Clio user LinkedIn group to start talking about documents that they have built in automation, and create a community of people who are sharing the fields, the forms, and the tips and the tricks that they're doing with this. So rather than it being one person having to recreate everything, it's now everybody contributing to creating everything. And this woman's been raising her hand for quite a while. I think
Yes.
the black jacket right here. Yes.
Yeah, I have a question that needs make money while you sleep schemes.
We don't do real estate in Florida.
What are the typical client price points? Who is going to go to, for instance, Foley risk thing and get online and get a solution? How much are they willing to pay?
Again, it depends on what the business goals are. We do work with a couple of law firms who simply give away these applications on their websites. They are lead generation devices. They're small, they're simple, they were built quickly, and they're designed to demonstrate the firm's expertise in a narrow and, to them, new and important area. So 0 revenue, client doesn't pay anything. At the upper end, big complex systems, you've got clients spending $50,000 a year for subscriptions to things that cover 50 states. So it really is, there's no single price point, as there's no single answer to how hard is it to build. If you're going to build a document, in simple terms to document automation, if you're going to build a form that is an affidavit to support something in a particular court, you can do that in an afternoon. If you're going to build a 50-state set of affidavits, lots more work. And I think it really does depend on what the practice is, what the client base is, and what the business goals are. In our experience, and I think it's true, you can see it in the way documents are used by law firms and some of the folks out there. Sometimes they are revenue generating, sometimes they are connection generating, lead generating, relationship enhancing. All of those serve different purposes, so the price point depends on what the real purpose is. Other questions? No, that's it. Good. Well, thank you very much. We're almost on time.